All right, everyone. It's May 18th, 2022. Let's get started. Thank you for joining us. We've got a nice group of people here today. We got a wonderful change of ages going on, don't we? We got this powerful phase transition between the ages with the negative, the positive, everything rising on the planet. And those of us focused on the light, he who keeps his face towards the sun finds that the shadows fall behind him. So we are focused on the positive and what unfolds, that creates, that helps, that supports life, that heals, that uplifts. And that's what the trust is designed for. That's what everything at BIC is for. And that's what all of us have in our hearts. So again, we appreciate each of you because every single one of our wonderful family of BIC Network, the affiliates, the customers, the consultants, those of us who are working together to create a better world, have virtues that are bearing on this great new transition into a golden age. And my good friend Randall, as you know, has been a lighthouse in this respect for decades, and just quietly shining his light to help people protect assets and to have peace of mind, peace and harmony in affairs. So we deeply appreciate all that. And let's get started with the next slide. We just have a few opening slides and then we'll get started right away with Randall. And as those of us who are new may know, that BIC is a project of verite, which means the truth. And Liberty Debt Elimination System is our other big program helping Americans cancel debts. But the Natural Law Trust, of course, is worldwide, works pretty much in all countries. Although we do hear problems in some countries, for example, getting documents notarized. We're here in the States, you just walk into a bank and it's either free or very inexpensive. And, you can get a document notarized, get your signature witnessed, and it's on public record. And I don't know, I'm hearing Canadians and English and people in other countries, it's not so simple, not so inexpensive, and not so sorry about that. But it's good to have some of the trust documents notarized. And we are members of the Worldwide Charter for Fair International Commerce. So if you haven't already, take a look at that page on the website. A lot of good information, good organization. We have our next trust webinar with Randall featured on July 13th. Today being May 18th, we do it every 2 months. And in between, of course, we do have our good friend Dominique Hackett, but I believe that she's taking a break in July as well, or June. Maybe it's June and then restarting in July. House of Freedom Trust.com with dots between or dashes between each of the words is a generic backup website for those who need it if you don't already have an affiliate link. And if you are not already a member of the newsletter list, join there. For those who need it, a phone number is 360-200-7521. And we have a bio here of myself, just showing a little bit of my background for those who see the visuals. Consultant in bank instruments program, speaker at former seminar and radio shows. And I'm working on a book. It's still forthcoming. We'll look forward to getting the time to finish that. Sovereignty Consciousness was completed in 1997, and then Cosmic Renaissance has been on its way, which will incorporate, embrace, include, and expand on that into enlightenment and the arts, which is where my real passion is. And that's where my base of asset protection in using the trust has been building from, to create a base on which to help usher in a new age through the arts. Randall Hillner is our head of the trust department. He's the inventor, or let's say the craftsman, behind the House of Freedom International Natural Law Trust, building on decades and generations of intel, mentoring, standing on the shoulders of other great teachers, writers, craftsmen, from law books all over the world incorporating and distilling the best of what would be perfect, what would be invincible in protecting assets into this trust design, taking what the elite used to use for generations. Those who we used to call the elite, I think maybe not so much anymore. There's a changing of the elite now. Those of higher consciousness are being empowered, but those who were known to be the wealthiest families traditionally used a trust design very similar to this, and Randall's been improving on it. And he's been trustee of a number of interesting trusts known as White Light Unlimited and One People's Public Trust. So Dominique Hackett is a protege of just an incredible being of great bright light, who has a great heart, who helps people, who is not afraid of learning curves and deep dives and mastering multiple things. And she gives the Trust Study Group webinars usually once a month. I believe June would be a break time for that. Keep in touch with her via her newsletter, the BIC newsletter that talks about her. And if you're a Trust client, you're on that list. If you aren't receiving it, look in your spam. If you don't find it, let us know, and we'll see if it can be rectified. Today's topic, creation of trusts. And I thought that was interesting. Randall sent over this theme, and I thought, it sounds kind of basic, but actually I looked over what he's doing and it's kind of advanced, but it's also very important to understand what creates a trust, why, under what circumstances, what kind of purposes, what kind of reasons, what kind of events would actually end up creating a trust. So you are co-host, Randall. I'm going to ask you to unmute and turn on your video and entertain us, educate us.
Well, welcome everybody. Thank you for allowing me to be here again. They actually gave me parole this morning just so I could be on this show, and I had my notes all in order, so I think I'll be safe to go back to what I was doing. Anyway, I'm going to do creation of trust in a different way, and just now's the time for you to maybe take notes on some of the things I'm going to talk about, because I'm going to give examples, and out of those examples.
And just remember to please tell me when to change the slides.
Yes. Yeah, Marianne, what are you laughing at?
Sorry, I'll unmute myself. Well, that was funny, Constance.
Okay, so that's a good start. I think that's a pretty outrageous start. So creation of trust is, first you have to laugh about it, and then you get into the slides. So without further ado, let's see what we can do with slide number one. Okay, right. Slide number one. So I'm going to read verbatim here, but then I want you to think about what's on there, and if you have questions on how that works for you and your trust and the way you want to approach it, then please do that. Okay, so the beginning one is a transfer by will of property owner to another person as trustee for one or more persons being the beneficiaries. So that's, you have a transfer of property that's, and the beginning of it was because it all began when people were going into the Crusades and then into war, and whenever anybody went off and left their family, they wanted to make sure that whatever farm, whatever property they had could be taken care of by somebody that was not their exact relative. One could be a relative and one would not, but that meant that that property would be taken care of. So the person going off either to search for new endeavor, new business, going to war or during the Crusades, all that old stuff, although we have it today, which is unfortunate. But so that person would become the trustee. And that trustee would look after the asset in that by the owner's device. What he does is he devises, or he entrusts a friend of his or a neighbor, or mostly what happened was during the church would take over and be the protector of the property. So if the client didn't come back, then the property would be either taken to the church or given back to the landowners that were still there. So the example of that is, let's say that Sally's will leaves the residue of her estate to Tom as a trustee. So Tom has the duty to act upon the trust for the benefit of B for life. In other words, she's giving it to T, and T is going to take care of it for the benefit of B for his life. And then when B dies, then the remainder would go to R, or basically his issue. So somebody creates a trust, has a trustee come in, the trustee makes sure that the property in the trust is taken care of and hopefully benefited by the good work of the trustee for B. And then when B leaves, then the remainder would go to his children or whoever he decides it wants to go to. So it's a very, very simple process. I leave you my property. I ask you to, on your best interest, to take care of this property for my children and grandchildren and further on down the line. And if you would do that, then we can make sure that this property is safe. Now, I don't even want to talk about bad trustees, but we'll leave that. We'll just assume that in most cases, the trustee always takes care of the property for the benefit of the beneficiaries. So Tom receives Sally's residence estate and in trust for her beneficiaries. Beneficiaries may be some of her beneficiaries. She may give it to other beneficiaries, or and so forth from that. So the idea is you have one person, sometimes two, but usually one person asking a trustee to take care of a piece of property for somebody else's benefit. That's a very simple explanation, and that's the essence of what we do. And so I think a lot of you, because you've been putting up with my information for 2 years, have gained a lot of knowledge about that. And so I want you to just remember, if you have any questions, that now is the time to put them down so that you can fire them off to me at the end of the show, or keep them for later, because once you become a client, then you have access to my email and my telephone, and we get to be good professional buddies and clients. So any questions on that? We'll come back to later. So now we need to have a change in the slide, please. Whoa. So we have a transfer inter vivos, which means during your lifetime, by a property to another person. Adam now transfers during his lifetime a piece of property for another person as trustee for one or more other people from that. In other words, Adam gives to Tom a piece of property for the benefit of C, D, and F children. Or it could be an endeavor, it could be the church. It may be that the beneficiary can be basically anything. Mostly we want to make a beneficiary a living being so that they can benefit from that. Although we've known of examples of people who have given a substantial estate to a particular oak tree in a park somewhere, just so that that oak tree may never be cut down. It may have some essential meaning, some existential meaning, or like that. I remember when I was living in Iowa, I had a black walnut tree that was, it must have been 100 foot tall. And the first branch was at least 50 feet up, and it was 4 feet around. And I said, I was leaving at the time, so it was too late, but I said, oh, I wish somebody would put that tree in trust. And at some point, that tree would be like a beacon of light for that particular area of ground. So that's the essence of it, is that you're taking property and giving it, trusting somebody to take care of it for somebody else after you pass on. So example here is Sam transfers certain of his land and securities to Tom as trustee upon an active trust for B being either Sam's children or some other person, doesn't really matter, for the remaining and for his life. And then for the remainder of that, go to let's call him Bob. Bob, that makes sense, Bob. So he is going to take that estate and he's going to have it for his lifetime, and the remainder would go to his children or whoever he decides to pass it on to when he starts to come to the end of his life. T is a trustee of that property for the benefit of, or the beneficiaries of Sam. Don't let the names confuse you, because when we go back, these slides are going to be available on this replay. And it takes a period of time to get really used to understanding how these things slide together, and how well they work together when you really understand what's happening. So, okay, how about another slide, please? Wow, slide for Charlie. Look at that bridge. Wow. So here it is, a declaration by an owner that he or she holds that property as trustee for one or more persons. All right, a declaration is made by somebody that she is going to hold the property for someone else. In other words, she doesn't want to give it to that person now, but she knows that when she dies, that's where she wants it to go to. And there's all kinds of understanding along that line, because usually it's some ages, the person that is going to be the beneficiary is not particularly ready to be able to be financially responsible. So she may wait, she may have it in trust and wait until he proves himself to be a proper caretaker of the property. All along, we know that basically all of us are caretakers of the planet. That's what we are. That's where we're here to take care of the property. Hopefully we don't defile it, but we take care of it and grow it well. And there's always that contradiction. Things are being blown up, but on the other hand, things are being grown all the time. I just talked to my sister in New Hampshire, and they just planted their whole garden, a whole couple of acres of garden. So it happens. And that's the idea, is we're the caretakers of the property of the planet. So Sally declares herself as trustee of a certain of her property for the benefit of herself for life, and thereafter for the benefit of her husband, if he's still around, for life, and the remainder at the death of his wife or Sally to go to the living descendants. So if they have a family, it will go to the family. There may be little stipulations in there that if grandchildren are abundant before Sally and Harry die, that some of that money would go to the health and education and lifestyle of the grandchildren. Okay, so how about another slide, please? Oh, now we're into a wet, slippery slide with geese and eagles and. Okay, so an exercise of power of appointment by appointing property to a person for one or more persons who are the objects of the power. In other words, this is where the trustee comes in and can appoint the power of that property would be going to somebody, and the trustees during that period of time would make sure that that asset is taken care of. If the person, the donee, has been given a power of appointment and makes an appointment to another person as a trustee, then the trust is created. So in order for us to have a valid trust, we need to have a person that can give that property and appoint another person to be the trustee for the benefit of a third party. That's the basic, it's the essence of a trust. You need three people. Okay, so Oscar devised an acre of land to Betty for life. Remainder as Betty may be made by deed or will appoint to B's issues. In other words, she may keep it herself for her life, but then appoint it to somebody else's issue, either during her life or possibly when she decides to pass on, she will have that issue, that property, go to another party. Meanwhile, Bob appoints the remainder by deed to T upon an act of trust to certain beneficiaries. So it's the same idea, is that somebody has a piece of property, they have an asset, could be, in our trust work, we have 4 schedules. We have a schedule for personal property, which would be like maybe silver and gold, and now people are doing a lot of crypto, so we have a schedule for crypto, and we have a schedule for real estate, and then we have the list of the beneficiaries, and so it's all laid out, and the certain powers of what all these people can do is written in the trust work. And it's also important to realize that as we go along, that this becomes, I've had a number of people lately come and say, well, I want you to do this, and I want you to write this for me, and I want you to write that for me. And I go back to them and I say, I have enough business training people coming in to begin with, that I have to make sure that you realize that when you buy this trust, when you buy a natural law trust, this is now yours, and it's now your responsibility to take care of. And it doesn't mean I won't help you along the way, or Tanzan won't help you, but you're the creative writer now. You have to decide what is it that I want for my estate to be, other than what I have in front of me. So that's what's important, is it becomes your trust. You and the trustees need to talk about whatever the results you are that you want to have for this trust, and how each beneficiary would get their purchase. A family came in last week, and one of the children was needing more particular educational supply because he'd been feeling left out. And then in another experience we had is that a particular child needed health care. So it's the trustees have the fluidity and have the power to make sure that the healthcare, the educational care, and anything necessary for what the beneficiary needs, that can be resolved, and that you as a client and you as the trustee are going to make that happen to keep the beneficiary in health and being educated and knowing. And if you really truly are teaching your children, then you're going to teach your children how to make sure that this trust runs on a regular basis, and it doesn't get mixed up in the everyday methods. Make sure you keep this trust separate as it is. You may have a number of trusts. You may have a trust because you have some valuable real estate. So you have a trust for real estate, and you have a trust for your business, and you might set up an educational fund for your children before they even get to need that at that stage. So that's the understanding is the trustee, the client has purchased the trust from us, and he and the trustees are going to make sure that it's run well for the beneficiaries, no matter what age. Okay, we have another slide. I'm really thirsty today, but it's raining out, and I realized that I was out riding hard this morning on my bike. So I lost a lot of fluid. Anyway, okay, so now we're into a beautiful flow of water. So just where I needed to come in and be. So a promise or beneficiary designation that creates enforceable rights in a person who immediately or later holds those rights, or who pursuant to those rights later receives property as a trustee for one or more persons. So in order to start the trust, somebody has to ask for somebody else to become a trustee and step up and create the environment where they are going to make sure that the assets are held in a place where it's safe, it's added to. Assets can be assets. Sometimes a good trustee will get rid of assets that don't do well. They might buy assets that are chancing well. We've had some people that as trustees, they bought a lot of the crypto in the early days. And so now they have to cater to make sure that crypto continues to grow and is held in promise for the beneficiaries. But gratuitously, meaning not under seal, promise by B that if and when A acquires a certain share of stock, he will transfer the shares to Tom in trust for B. But if he just says that but doesn't do it, there's no trust. So unless A not only acquires the shares but also transfer them into the trust for Tom, then it doesn't matter. So it's important that you might think about having these assets that you want to put in a trust, but you literally have to do that. If you have valuable property, you can put it in trust, have the trustees would sign on that. If you have real estate, you actually have to go to the real estate office and transfer the title of the deed. And that often means that you have to go down to the county recorder. And this is a lot of my European clients are frustrated because over there they don't have a county recorder, so they have to go through all this rigmarole that is more it's just more aggressive on you to produce than it is for the easiness of you just to say, hey, look, I'm just transferring my title of my land to somebody else. And I know in the US, it's a fairly simple process. And actually, I'm going to have to do some work for a gentleman up in Canada that's having a hard time with the banking system up there. So it's sometimes the banks are not really savvy to the workings of the trust, so they don't know how to just say yes. All they do is they want to just make it difficult for you. So I don't understand quite that much, because if I was a banker, I'd say yes. What can I do for you? I'll take your money. I'll make your wealth grow. That's my job. Okay, so that leads us into the next question, I think. Next slide. Up.
So,
Boy, that
my
was
brother,
it.
as before we get into the questions, everyone, I just wanted to comment that one of the great teachers we studied with taught us that the mind is like an ocean, and that most people's thoughts are mainly near the surface of the waves of the ocean, right? And not very many penetrate deep. And he said the measure of evolution is to be able to pick up thought closer to its source. And that's kind of what you're doing with this topic today. I was fascinated by it because while we've been talking about the construction, the operation of trust for years, today we're going more into the essence, more into what's the seed, what's the origin, what's the purpose, what actual events or purposes or desires create a trust. I think that's fascinating.
Yeah, and you did. You actually pointed your finger in that direction, and I picked up on it at the right time. And it was an amazing 4 days of me to go dive into the law book and go, oh shit, where am I going to find this? Okay, I know it's in here. And to be able, you've in a sense brought it out of me. So thank you for that too.
And would it be okay with you to invite our dear friend Dominique to say a word before we continue with the questions?
Dominique, do I know Dominique?
Yeah.
Just a new client of ours. Oh no, I know Dominique. Where are you, girl?
Hello.
Yeah.
Dominique, one thing I think that you could contribute to this particular discussion is your discovery of the amazing matrix of clauses that Randall has added into this natural law trust design that no other trust has. I think that's something very valuable for people to know and understand.
Well, what I can offer to everyone is that I've spent about 30 years in construction, reviewing construction contracts. And so I'm very familiar with contract clauses and a lot of legalese. And it's such a pleasure because part of my job of Randall mentoring me is that I have to read other trust indentures. And as I read other trust indentures, I'll come across a section, I'll go, oh, this looks cool. What do we have? And then I go back to our trust indenture, and Randall has written it in such clear English that thus far, I've been studying since 2019, I've not found anything that is worthy enough to try to add or modify our trust. I keep looking because that's my job. Try to find something. And every time I go back to the indenture, Randall, it's so satisfying to have such clear English. And for example, you've written such an excellent clause in the specific powers of the trustees that enables them that if there is something where they want to help administer the trust and be clear about what they're doing, you give them the specific power to write a bylaw or to write something that helps clarify. But the intention of the trust is so clearly written in your trust indenture. Thank you so much.
You're welcome. It's all your fault. And yes, and the thing I like about you is that you've actually stepped up to the plate to, not only mentor with me, but to push me into a higher level of focus on myself, on trust myself. So just remember, when I pass, you're going to get about 1,000 pounds of law book that will give you many, many, many clauses to look at. Maybe I should
Well,
say you'd be looking for the pauses, not the clauses.
That's so beautiful. But I have requested that that not be for another 30 years. So
Okay.
my request is there.
All right.
Thank you.
As long as we have fun like this, I'm okay.
Is that your secret to the recipe? Is the pauses within the clauses?
The pauses within the clauses. Absolutely.
Okay, well, Ocean has asked a question. He says, when opening a trust bank account, some banks require that a living person can only be the beneficiary and not another trust. If you want another trust as a beneficiary, is there another way to get around those restrictions besides going to another bank?
I can't imagine the trustee has legal and lawful title of the property in the trust. So I can't imagine why a bank would need to know. You might want to know the name of the beneficiary, but the beneficiary doesn't own anything within the trust itself at the moment. He only gets it later. So I don't know how to deal with that. I mean, sometimes you got to walk. I just talked to a frustrated person, and he said, I can't even find a notary. So some places notaries don't even exist, I guess. I don't know why that is, but I don't know. Maybe it's fortunate that down in the US, a lot of the things that we have here really benefit along the law of trust. And I have an idea. It's because 200 years ago, when the Rockefellers and the Kennedys all started this, that they made it this way so that it wouldn't be a burden on the people putting things in trust. It would be a burden for people trying to attack the trust.
I can't imagine why a bank should have any say over who the beneficiaries are.
Really? Don't know. Anybody else?
Okay, we have a couple hands raised. Let's see. I'm going to go to IM1 and ask you to unmute. And IM1, if you can please, there you are. All right, you're on the air. If you can speak to us.
Hi, how's it going?
Well, good, I'm one and you are two.
Yeah, awesome. I like to congratulate you guys for your work because it's beautiful.
Thank
Simply
you.
like perfect. And my question is, how to create credit as a trust entity?
I think it's the same way you would go out into the business world and you would create a business, only this time you're going to go out and you're going to have the name of your business be the one that writes the contract. And you as trustee would entertain the contract, you and possibly the second trustee. Some people want both trustee signatures, some people just want one. If you look at our trust indenture, you'll see that for the bank instruction, there's only need for one trustee signature. It just depends on the bank and it depends on the people. But if you, let's say you go out, you're a contractor and you do a small business, you do an addition to a house, and it's all under the name of the trust, then there you go. You've got credit under the name of the trust, and that trust now has a credible issue.
Yeah, so it's basically like this thing as using like a negotiable instrument, but under the name of the trust within both signatures or more, right?
Yeah, well, a lot of times bank will want both signatures, but on the trust indenture that you get from us, it's either or. Either one trustee or the other
Oh.
could be the main signature on the account.
Oh, perfect, perfect. And the next question, Randall. I got a problem. I basically escaped from a political, um, basically like a political persecution in Brazil because the Communist Party was like basically persecuting
Right.
everyone who was not or Christians and you know all of the people. And since I'm domiciled here, and I know just a few people here. Uh, I invested in the fully activated trust, and to be a trustee and to create that EIN, I would need to have like a social security. How can I do that since I don't know, I don't know, I just know only a few people here in the US. How can I
Well-
solve this problem
Well,
since
you
I
could
can use
ask
my
around for your friends. Say, look, I need a
Yes.
social security number so that I can get accredited a bank account. But also you can apply for an EIN number with a US residence. That's easy to get. It takes you about 15 minutes on the web. You just go online and you get an EIN number. Now, I know the EIN number is scary for some people, but it's not. It's just a number that's used so that the IRS knows who that particular person is down the line. It's nothing to be afraid of, but everybody
Yes.
needs it. Unfortunately, the banks are dominated or owned by the Federal Reserve. So
Yes.
at this point in time, we don't have a choice.
Yeah. Could I create that even if I'm only domicile as a sovereign visitor? I'm only domicile. I don't have a U.S. residency. You know what I mean?
Well,
I
get a mail,
still
buy a mail stop. Go to a mail stop place and put your name down and get a mail stop, which is what they call it. That's where when we were sailing at sea, we would like when I leave to go from San Francisco, I'd go to my mail stop guy, say, hey, listen, I'm going offshore for 2 or 3 months. And when I come back, just have my stuff ready, and I paid him. And so that gives you a legal address here in the US. I would think you can do it in any European, I mean, all European countries where there's any sailing community would have those facilities.
yes. Where exactly is this? I'm living right now at my parents' residence here in Florida, so I do have like a lease contract sort of stuff. Uh, what's the name again of that place? Sale? No, mail.
A mail
What is the
stop?
name of that?
Well, you just look,
Mail
you look,
stop.
well, if you go to look on the UPS or FedEx,
Oh, okay. Okay. Yes.
they're
Okay.
usually, they usually also offer other shipping services. And sometimes, I mean, I'm just on Kauai, which is not very big, out in the middle of the ocean. And I can go into a FedEx place and they usually have the ability to have a mail stop.
Oh, okay.
And they
Oh,
have
Randall, thank you.
the
Yes.
person that had a question on getting getting his signature notarized, that's where to go to. If you need your signature notarized, you go to a FedEx or Express Mail, and they usually have the mail stop, notary services, all of that stuff.
Oh, so with that, I could basically get that EIN number after that.
No, you go to a mail stop and you get an address. What you're going to do is you're going to get a US address. Then you're going to
US
go
address.
online. If you're a client of ours, I'll send you a form It tells you exactly how to go on the web, and using your US address, you write in to obtain an EIN number, either for the trust or for yourself.
Perfect, Randall. Thank you so much. That was like kind of like a blockage, you know. I've been postponing this only
Yep.
because of that reason.
Okay, well, keep trying, and if you need help, if you're a client of ours, just ask the office for my email, and I'll help you with that. You're in Florida, you should have plenty of places in Florida, because it's so, I mean, it's all people that come down from the north during the winter. So I'm sure there are plenty of places where you can get UPS and FedEx and mail stops, and EIN numbers are done online in 10, 15 minutes.
Thank you so much, Randall. Dominic has already gave me your email, so I'll be sending you. Thank you.
Okay.
Yeah.
You're welcome.
Thank you, Mark. Okay, thank you so much. And we had a question in the chat that relates to the EIN. If a trustee grant or obtains an EIN for the trust, will it place the trust under federal jurisdiction?
Well, it's a fair question, because if you haven't operated in this arena, I mean, you and I have been doing this for 30 years, Townsend, and
Yeah,
we know that it's not a big deal. But for people who have just come into this, it's not a big deal to get an EIN number. And there's all kinds of ways to deal with the IRS if they're too scary for you. You know, just there's always around it. There's nothing to be afraid of. An EIN number is just a number. It allows you to open up a bank account either for yourself or for the trust. So shouldn't have any fear there.
in short, the answer is no. Yeah. Okay, we have David on who's raised his hand. So I'm going to ask you to unmute, David, and ask you to speak to us.
Thanks, Tanzan. Randall, it's a pretty straightforward question, hopefully. I've opened up a crypto wallet, but it doesn't allow ask for trust documents or anything like that. I've purchased a trust through you.
Right.
But it just, so I'm using the trust email address. Is that enough to be allocated to the trust? And if I just write a minute saying I've allocated this, either monies towards that?
You're let me see if I understand this. You're trying to use a mail stop as an EIN number?
No. For a crypto wallet, I'm opening up
Oh,
that
crypto wallet.
and just
I'm not
using
sure.
the email address of the trust. There's no been requirement for trust documents or anything. Is that enough?
If that's all they want, that's enough.
Right, thank you.
Generally, you can create a minute to transfer ownership of the crypto to the trust by including the receive address of your wallet
Right.
in the minute.
Great, thank you.
Okay. Thank you. And Mark, I'm going to ask you to unmute. You've got the air if you want. Mark?
Hi, thanks. Can you hear me all right?
Yes.
Awesome.
Welcome.
All right. Thanks everybody for the webinar. This is awesome. I've been studying trust for several months now. I just came across your information. So I've been going through your past webinar videos. And so hopefully this is not a question you've already answered, but one of the main struggles for me to get my mind around is how this trust is really private. If, for instance, you know, we want to do business online, and so we need to engage in payment processors like PayPal, or we need an Amazon account. You know, it's unlikely that you're going to be able to use a pure trust to hold those accounts. So my thinking was to use a statutory entity like an LLC to do all the public side of the business. But then I heard you mention in past webinars that you can either have the LLC pay the taxes, any taxes up front, and then pass the rest along to the trust, or just pass profits along to the trust since it's tax accepted anyway. But my question is, when you're using these online services like PayPal and Amazon, they're going to, you know, obviously send information returns to the IRS for the LLC, but then isn't the LLC, being a statutory entity, still obligated to provide information returns to the IRS when it distributes anything to the trust? So the trust would see that this trust name with this EIN number received distribution. So how do you, I mean, I assume the IRS would come after the trust in that instance, no?
It may or it may not. It just depends on the volume of money that flows through there. I've done it both ways. I've done it with the LLC in Hawaii, and I just didn't like the excise tax that Hawaii was charging for their LLC. So I just dropped it all together, and I just used the trust for my whole business process. And since I'm mostly online business, I didn't have to worry about a lot of stuff hanging about. So I was not concerned about it. So if you're using a statutory entity, then yes, there's more liability there, because the eyes are open and always looking out to snag something. Whereas if you just use your trust as your storefront and your back office, then there's less visibility. But it depends on how big your business is going to get also, because if you start generating a $250,000, $500,000 a year, then somebody's going to come knocking on your door. But we have ways to temper that as well.
Okay. Yeah, I don't see any business being quite that big. So you have, well, I don't want to ask you personal questions like that, but for instance, I haven't looked into this yet, but is it possible for, say, to have the pure trust have a PayPal account in its name, and Stripe account, and an Amazon account, etc.?
Sure, if you want, but that's you putting yourself more out into the public realm. Whereas if you can find other ways to collect the funds, then that's what it is. But I do have PayPal. I use it. I don't pay attention to the process of working with it. But then again, I'm not generating $250,000 a year.
Well, Mark, if I may ask you a question, is what's the problem with just holding those accounts in your personal name? And okay, you're trustee of a natural law trust. You don't need to put all those accounts in the name of the trust. You can hold them in your personal name.
Right.
Yeah, I guess this is more of a personal thing. I'm just trying to get absolutely everything out of my personal name, just for my own convictions. Like I've already sent in my, well, I don't want to say, I don't know, this might get on YouTube. I don't want to say all that, but I don't want to really use the Social Security number anymore for anything other than applying for EINs for other entities, if that makes sense.
I went
Makes
down that
sense, but-
road in the 1990s. I went down that road of trying to get rid of the SSN until I started getting further educated and realized that as a sovereign, you and I are American sovereigns, okay? We have the right to interface with the system using that commercial number. If you understand, it is not you, it doesn't represent you, it just represents the fictional entity that they gave you, the commercial entity with the all cap name. That's your commercial vehicle for interacting with the system. It's okay, that's the number assigned to it. So what? Use it.
Right.
It's not going to enslave you.
You'll find that just Social Security number is never in small letters, it's always in all cap letters. Because it's a fiction. That's who you are as a fiction to the government.
Right. Yeah. Okay. Well, yeah, I appreciate the feedback.
Yeah, it's the art of learning how to operate in the private. And what Randall's given us is a Rolls Royce for driving our commerce in the private. And as Randall said, he kind of got tired of an LLC. Dominique said the same thing. I got tired of statutory entities. I had an IBC. I've had statutory offshore trusts back in the 90s. And so I realized I don't need those anymore. They're just too much hassle. They're not enough benefit. And our natural law trust gave far more benefit with much less hassle. So why even bother with all those? I just let go of them. And I'm similar to you in the sense that I also don't bank in my personal name. But other than that, I don't have a problem with having my name on the kinds of accounts, commercial accounts that you mentioned. Also, when you have a bank account for the natural law trust, you notice that when they issue the debit card for it, the Visa or the MasterCard debit card, they put your personal name on it. Why? Not because you're the owner of the account, it's because you're the user. It's like a corporate account where you're an employee of a corporation and the corporate card comes and it may have the corporation name on it, it may not, but it definitely has the user's name. You're just a user of the card. You're gonna rent a car or book a hotel room or do something. They don't want to know your trust name. They want to know your personal name. You know?
Right.
Yeah, I guess I understand all that, and I guess my hang up is, and I don't want to dominate this conversation or anything, but I guess my hang up is I just don't want to do anything where the social security number would then have to submit a tax return. So, you know,
Submitting a tax return is always optional anyway.
You might benefit, in addition to our trust knowledge, you might benefit from looking on the BIC website. Up at the top where it says resources, you click on that drop-down menu and you go to freedom from tax and read through that section, because there are a lot of great resources there for you, since that seems to be a great concern for you.
Right. Okay, thanks. I'll check it out.
Okay. And we have Clint. I'm going to ask you to unmute. Clint, you're on the air.
Hi guys.
Hi, Clint.
I apologize. I got a little late into the call, but I was just kind of just listening to you talk about the trust, the way that it's kind of set up and that sort of thing. What I wanted to find out ask was, so much of what we think trusts are is for defense, protecting assets, that sort of thing. The trust that y'all are talking about, can you talk about how it can also be used for offense to, if you've got to go after somebody, that sort of thing? The reason why I'm asking this is because I've been doing a lot of reading from Christian Walters and how he transitioned over to, he just wanted to be proficient in trust only, because I have the same thinking he does, that everything that we do in this world, especially commercial, it's all trust. So how can we use this particular trust offensively as well as in commerce?
Well, I don't know the exact section number, but it's in the powers of the trustee. It says this trust has power to sue or be sued. So you can be on the offense like anybody else. If something is going on that is harming the assets in your trust, then you have the right to sue, to create a case against the people, doing a disservice to your trust. Does that make sense?
Yeah, that's part of it, but I'm also thinking just in other areas where, like if you're getting pulled over by a statutory agent.
That's a different story, and that's not what we're talking about here. We're
Yeah,
talking
okay.
about the IRS and that. Yeah, there are plenty of places out there. In fact, if you are a member, you can get my email from the office, and I'll direct you to 2 or 3 groups of people that are out there done incredible work in just that arena, traffic stops, all the bullshit stuff that happens to us that doesn't have to be. So there's
Right,
plenty of ways, there's plenty of ways to deal with that.
Okay, and also I'm just thinking about, inner circle, like kids, immediate family, that sort of thing, as far as even if they're not wanting to go the private path or as deep as where I want to go, they can still be, protected with that trust.
Sure. Just because they're a beneficiary, let's say you have 3 kids and they're all beneficiaries of the trust that you've set up for them. And if one of them is a little wayward and he's getting himself in trouble and you see he's going to be attacked by somebody, then the trustees can just withdraw his beneficial interest and he has nothing. And then later on, when he works his way back up into a honest situation and gets clean in what he's doing, then he can, then the trustees can reissue his beneficial interest. It's called a spendthrift trust outside, and I just included as a paragraph, as a schedule in the trust that we have.
Okay, thanks, guys.
Sure.
Thank you, Clint. Much appreciated. Okay, Randall, I had a question I thought might fit your theme today, since
Okay.
you have a great focus on what is causative, what is seminal, what kind of situations in life would end up creating a trust. And most people are familiar with the will. And I think people could benefit from understanding, let's say somebody writes in their will that when I die, I would like my assets to go to so-and-so. What is the difference between doing that and writing a pure irrevocable contract, private contract trust that says essentially the same thing, that when I leave this world, I want to leave these assets to so-and-so?
Well, it's exactly what we had in the first section, the first slide we talked about was setting up inter vivos trust, which means that the person creates the trust now while he's still alive versus having a trust devised by the passing of the person. I mean, it's the same thing, only one is written now, one is signed now, one is set up now. That's what we do. I'm sure most of our clients with natural law trust they're all alive. Otherwise, they wouldn't be listening to us. But maybe they are, I don't know. But anyway, but that's just the difference between an inter vivos trust and a trust devised by will.
And what would you say is the greater advantage of doing it via the trust as opposed to doing it via the will?
Because the will has to go through probate if it's over a certain amount, whereas if it's all in trust beforehand, it doesn't even have to think about probate.
Mm-hmm.
And also, if they don't do it until they die, then who's to say that somebody won't come in and rain on their parade while the funeral's happening? So it's much more intent to do an inter vivos trust and do it now, do it as soon as possible so that those assets are protected. And what happens is the longer the trust is in existence, the more solidity it has. The the base power becomes stronger because it's been around and activity has been happening. That's why I tell our clients that it's very important to keep a paper trail. We want that paper trail to lead into, okay, why did I do this? Like the questions that people ask me, I say, don't call me, but write me an email on it so that I can have it down. We can have it down on paper and you'll have it as part of your trust. People still don't get sometimes that having what the value of minutes are in the trust. So every time an action, especially any kind of activity, action, or decision that's going to affect any of the assets in the trust, you want to have it being done by the trust rather than you.
And
So-
additional difference I can think of that's real basic is that a will is not a legal entity that can hold assets. Therefore, it cannot hold
Right.
a bank account, it cannot hold real estate. Whereas
Right.
trust is a legal entity separate from, and it has its own EIN, as we discussed, its own ID number.
Mhm.
It can hold real estate, it can hold bank accounts, so that when you pass away, whoever is the successor trustee just seamlessly takes over.
Right. There's no stoppage in the
Stoppage.
essence of what's going on. Whereas if there's a will, it all has to go through that whole process of being changed around.
Mhm.
So yeah, inter vivos trust is much stronger than a will.
And so we have some more questions here. I think I am one is asking about where to find reliable people, I guess for being a trustee and so on. What qualities should I seek and so on. And here Randall might be a good opportunity to explain the opportunity for being your own trustee so that you don't have to be worried about who can I trust, right?
Well, that would be one part of it. And the other part of it is that I have a bibliography. I think, isn't it on your website? The bibliography that I use.
No, it's somewhere in we've published it, I think, in the trust itself. You provide it, don't you?
No, I have it as an add-on for me, but I think maybe might be an idea for us to think about where we put it on the website as an aid to
Yeah, we could do
deciding
that.
about the trust. It does take some work, and it's I have a couple of books that are only 100 pages, but if you learn that 100 pages, you won't have a problem with working around the area of trust law. But it is, it takes some effort. Actually, it takes a lot of effort to get friends or people you know that understand the law of trust, and it is to do it yourself. But you do, in order for trust to be vibrant, it definitely needs to have some non-related trustee as part of it. Because if it's your asset and you put it in trust and you're one of the trustees, then you haven't separated it enough, and then you need to have a second trustee that's not related to you. And that was one of the things I almost included in the paper today. There's a perfect example. It's a perfect example of that separation between asset and power.
And then successor trustee.
Can do that. And when you get to a successor trustee, then a generation has passed by. Usually the grantor is gone. And so a successor trustee could in fact be related to the family.
All right.
It's always better to have a secondary person that's not related to keep that separation of asset. I mean, yes, you can be a sole trustee and, but the idea is to have that, my trusts are all set up for beneficiaries that are charitable.
Well, Colette says, does BIC offer trustee services? And if so, what is the range of fees?
I charge $3,000 a minute, but I do really quick work. No, yeah, there's professional trustees out there, but they're all lawyers, they're all statutory, and they're gonna be, are they gonna serve you, or are they just serving their pocketbook?
In short, Colette, no, we discourage that. From time to time, Dominique has consented to perform that service, but she accepts cases on a case-by-case basis and is very selective because it's a big responsibility. So we encourage most people to be their own trustee and find another unrelated person somewhere to be the co-trustee, which isn't hard to do. Most people can do that.
Being a trustee is a lot of work, Townsend, we know that.
Well, it may or may not be a lot of work, but it's a lot of responsibility.
Responsibility.
It's someone else's affair.
Yeah, in particular, if it's somebody else, there's a lot more work involved than when you're the sole trustee of your own trust, and you know that it's going somewhere else. You don't have to worry about it, and you have that separation because it's going to go not to anybody in your family.
Mhm.
Then you just do the work that's needed to be done to keep the asset growing.
Mark says, can you have multiple trusts with the same exact structure of grantor, trustees, beneficiary with only different assets? Or would
No,
effectively merge the trust into one?
no, you need 2 out of 3 would have to change. In other words, if you have 3 trusts, then you'd have to have 3 different people in each trust. So again, you're looking at the separation of assets from who you are. And if you've got the same 3 people in 3 different trusts, then you haven't really separated things out, especially if the beneficiaries are the same. They say, well, we're gonna, we want to do this, but the beneficiaries are all the same. I say, well, then why are you having 3 trusts? There's no separation. So
Mhm.
if you have long questions about that, then become a client and I'll work with you on it.
And here's a very long question in chat from Wade, but I'll just abbreviate it, and we can address the rest of it outside the context of the webinar. But he says, is it necessary to register the trust with any one government entity in the US?
I get that all the time. No, what are you going to register? There's nothing to register. You have an unalienable right to have a contract. That's the one of the prime. That's it's the 10th Amendment is the right to contract shall not be abridged. Either the 9th to the 10th. The right to contract shall not be abridged. So, and that's why trusts have been so prevalently powerful here.
Absolutely. I am one. You still have your hand up. Would you still like to speak to us?
Hey. Oh, yes. Basically, guys answered all the questions I had. The only one that I can think by now is about the OPPT. I know this is a sensible subject, but congratulations to Randall. I first came into contact with with Brilliance in Commerce through the OPPT. Just so you guys know, I was congratulations. That was phenomenal. That is, like, to be honest, one of the biggest contributions I've seen, like, in many years. By accident, I had just came to US. I had been here like many times before, but as I explained, I was I left the country. I left Brazil because if you know that passage from the Bible, Book of John, when Jesus they tried to make Jesus the king of the Jews, and he leaves. He basically he runs away. So they were trying. They wanted me to be like this kind of person there, you know, like as they call like a superstar. But I saw that there was like basically like something that would be bad for me, and so I left and came here. And while I came here, I think through like a higher intelligence or guidance and or a higher force, I was presented with your material, which was the OPPT files. But the files were from they were translated to Portuguese and many other languages in Latin America, Europe, and there was like this group that they called like we are I am something like that, but in Portuguese it's and there was like this leader that's Italian, so he was exposing I don't know if that's you know about that, by the way, but he was exposing this to make people free. So I got into contact with the files, and I was very surprised because there was like that declaration of order to be sent to all the parties of the government and all this stuff. So again, congratulations. And my question is, should I really use that, even though I know I have this other knowledge about the trust? Should I still rely on, I mean, to use all this information and send to all the parties? Although I have these files, as I said, translated to Portuguese and some to English, like the affidavit and the declaration of order. I believe all of them are translated to English, although most of the English documents, I mean, all of the English documents, they don't have like a guidelines to as I say, of procedures. I mean, who to send, where to-
those papers weren't
Yes.
they weren't for personal issue. Those papers, we did it as a public trust to serve on the bank officials and the government officials to say that you're in default here because of the things that we're going to list for you. But it wasn't for something to be used personally. It wasn't like all of us, we already had trust and we had done this. And this was more in combating and working with the Uniform Commercial Code, which is different than working with a trust, natural law trust. So I wouldn't, I would hesitate to encourage you to use that at all. It's something, it's a historical background. And if you take it in and use it as that, if you absorb it historically and then run down the different cases that we talk about, you'll have enough, and you'll have enough with the natural law trust to substantiate your own personal process. And you can use, you can use part of the OPPT paperwork as, and I use this as part of my declaration, but I wouldn't use it as a whole unit. It's more, that was a publication for against the bankers and the governments, that we were putting them on notice that they did not have the power and control that they thought they did.
Yeah, so since it is like an international document and operates under the like natural law and UCC and common law, you think even though, as I said, I still feel, there is like an international, and it will always have this international like surveillance, even though I'm here and I'm not doing anything wrong whatsoever. But should I rely just on what you're saying is that I can, basically just have these documents as a means of, personal power or to understand, because I read everything already. to understand it and
Yeah.
use it for personal use, right?
Use it as an educational tool. And the best thing to do is
Oh, perfect.
you take that
Awesome.
OPPT, you take that, I mean, I don't know how much you have of it, but I remember we had probably 1,000 pages and
Wow.
you use that as an educational tool. And then if you still need more and you're a client of ours, I'll turn you on to some other places that will give you the same kind of documentation from a different place, from a different light. And it will give you, it will coordinate with what you've got with the OPPT. And all you need for yourself is a natural law trust.
Yeah, yeah. That's what I thought. You know, I thought that was like sufficient, enough, because all of your job was like, to me, that was like there's no words really. It was like a 360. You know, it covered all of the, got all the job done. You know, so, but I understood that exactly what you're saying, that the natural law trust was enough to protect like us in private.
Sure.
While we could use some of these documents, let's say, to serve as a bank notice, you know, before court or before going to court, you know, to serve them to understand that we are operating under natural law too.
It'd be better not to have to go to court at all. I mean, and
yeah, exactly.
There's all kinds of stuff out there, and use them as educational tools. But this, you know, Townsend and I, we could easily write a 3-page trust, and it would be as valid as the 36-page trust that we give to every client. Because that's all you need. It's just a contract between 3 people. And if it's run, if it's written and it defines exactly what it is you want, and it's signed by the 3 people, there it is right there.
Perfect.
But what we do with the natural law trust is we incorporate a lot of effort and surrounding material with that, so that you begin to understand the whole essence of what a really fulfilling trust is.
Yeah, and this is where the beauty, that's what's beautiful about it, because it has like profound knowledge on law, you know, real law, not like statutes or codes. So I can really feel comfortable, you know, using it, because I started studying common law too, UCC, natural law, all these categories per se, you know. That gave me like a very good foundation. Thank you so much.
You're welcome.
Enough, you know, you got. Thank you.
For the benefit of the other listeners, everyone, Randall was trustee, I guess still is, of One People's Public Trust. And Randall, you can explain more if you wish, but back in 2012, Randall traveled to Morocco and Switzerland, and in Switzerland filed the foreclosure papers on the IMF and the World Bank and the Bank of International Settlements in Basel. And Randall, this is my simple understanding of it, is that basically these entities, institutions, governments of the past had not been very good at distributing the wealth of the world to the people. And so something was needed to replace those old worn out mechanisms, something that would be an efficient distribution vehicle, right? If we're going to create a new world where the wealth is universally available to everyone who's harmless and everyone who isn't trying to take over the world and enslave everybody, then a new vehicle would be needed to do that. And my view, that trust was the template for that.
Yes. Yep, it contained all the knowledge that you needed, and it served its purpose. And again, it's for the people. It's not for a person. It's not for you as an individual. You don't need that. What you need for your individual work is a natural law trust.
Oh, here's a basic question from Clint. How does this trust differ from a common law pure trust?
Just a name, I believe, and the backing that you get. I mean, people out there say, oh, I'll give you a common law trust. And the words, like I said, you and I know that we could write a trust in 3 pages. But the idea is to what's behind that 3 pages and how do you back it up? How do you know to go where, look, this is where where's my buddy in Santa Barbara. Dominique, sweet Dominique, you slipped my mind. You must be on the beach already. Anyway, the idea is that you can keep it simple, but you back the knowledge up with essence that you know is solid. So you can use 100 pages, you can use 30 pages, you can use 3 pages. But the idea is, of the 3 people that are going to do the trust, are they going to stay in integrity?
Can I add something, Randall?
Well, of course, sweet.
And my understanding of common law is that common law has been created as statutory law in like states in the United States. Delaware has some statutory
Right.
common law procedures and so forth. But common law is basically judicial precedence. And
Yep.
so what we're attempting to do anytime that we're engaging in contracts with one another, we're trying to honor, well, how was it done in the past that it worked out really well for people? And so generally speaking, my understanding of common law is judicial precedence, and then also the idea that hopefully we get back to, if somebody wasn't harmed, then there shouldn't be a foul. And that's the problem
Right.
with all the statutory rules and regulations. So when most people talk of common law, they're really trying to ascertain, is there injury somewhere? And how can I work in harmony with people so that we have a really strong contract?
Exactly.
And then Dominique, you contributed an article about, or a video about natural law and the relation between the two.
Yes, there are some excellent conversations going on between lawyers, especially in regards to the World Court, about the importance of natural law. And that natural law is that innate sense of how we live as human beings with one another, that's not given by any government or given by any entity. It's a knowingness that human beings have about how to interact with one another. And it honors ideas like karma and cycles, and how do you care for our planet and community, and at the same time care for yourself, and the idea of not harming one another. So natural law, they're finding, is really fundamental to all societies and cultures. That's a good foundation stone.
Right. Yep. Again, it's your integrity between the 3 people. They're going to create the trust. Oh, what a beautiful ending.
Okay, well, thank you. There's a question that could be answered some other time or privately. Kay asks, hello, how does one run their day-to-day business that is held in a natural law trust, writing checks to pay vendors and so on?
She's a client. She can write to me.
Okay, yeah, the simple answer, Randall, I guess you would just say, is that you just do everything in the name of the trust instead of in the name you were previously doing it in. And there are a few variations on not commingling funds and things like that. But
there's your basic. There it is, right there. There's your question. There's the answer. Run it like you run a business and be in integrity, and you're all set.
Yeah. And of course, everyone has access to Randall as a private client for private questions on details of such things. So we have had a lot of fun today. Our next time with Randall on this Zoom show, let's call it a show, is July
Oh, really?
15th. And we'll look forward
The
to that.
Randall and Townsend Show, along with Dominique.
All right. Thank you, everyone. A grateful heart is a magnet for miracles. Remember that, be that, live that, dive deep, fly high, and be well. And Dominique, thanks for your comments. And Randall, mahalo.
Yes, thank you
Aloha.
also. Thank you for providing the space for us to do this. Thank you.
All right. Well, from
Aloha.
across the ocean, we'll send the dolphins with some messages of mutual trust and appreciation.
Yeah, and the whales are here now also.
Wow. Yeah. All right. Well, one of these days you'll have to hold a conference for everybody over there.
You'll just have to fly over here.
That's right.
Aloha,
Okay.
everyone.
Aloha. Thanks.